Your Lordship, like to mention listing of a criminal epidemiology on 17th. 17th of August.
Prayer for listing, please give it to the court master.
Right. May I please, Your Lordship?
Yes.
My Lord, I beg to mention item number 9, Your Lordship. Kindly, the matter may be passed over.
Nine.
Yes. You want an adjournment?
My Lord.
I is for bail.
My Lord.
Okay. On the prayer made by Mr. A. Rahman, counsel for the applicant, matter stands adjourned today. Liberty granted to the state to file objection if so advised.
I don't know whether we had already taken time. We actually distribute our matters myself. It's not. written.
Just go through it.
A lot.
If
I'll
not,
go through.
I've given you liberty. If it's not there, just tell to the court master, we'll delete that.
Oh, he said that we have not taken time. Perhaps it has come up for the first time.
First time.
Oh, first time. Then we will be filing it.
As Jan, then the ABP is present.
Master Lord.
After how much time?
2 weeks, we will file our affidavit.
2 weeks.
Master Lord. Right, please, Your Lordship. I am paying for listing of a criminal appeal, my Lord. Okay.
List item number 1 for admission. Yeah, please, this is an appeal against conviction under 302, my lord. And life imprisonment is there, my lord.
Okay, so we'll issue notice.
Lord, I will file objection. Lord.
By the bail application.
That's it.
I'll maybe call for that.
So D. Bora for the petitioner, for the appellant.
Yes, lord.
And this A. Begum, done an APP appearing for the state. Appeal under 374(2). Notice returnable in 4 weeks.
That's it.
The appellant shall take steps within 2 days for service of notice on respondent number 2 by registered post with AD, as well as by usual process to be routed through the jurisdictional magistrate. We started 2 weeks. Bill objection.
There is also an IM, my lord. There's a
That's right. I'm saying bill notice is the application for bill notice and object time to file objection. List after 4 weeks.
I may be taken after the receipt of LCM.
Else may be called for.
So it was a
Yes,
LCR.
I am.
I shall be considered on the seat of LCR. Okay.
Leave of this, my lord.
One, two,
Item number 2.
Same order will pass here. Same order will pass here. Ms. D. Burbank for the appellant.
sorry.
Same notice call for the records. Application for bill shall be considered on receipt of LCR. Ms. Begum, APP for the state.
A copy may be served to you.
Should we file objection in the IA
Yes.
and appeal?
You want copies?
Lordship.
Yes, sir, copies.
Copy.
LCM may be called for.
Yes, quite.
Lordship, after 2 weeks, they'll
4 weeks.
4 weeks.
4 weeks.
4 weeks. Bill will be considered on receipt of LCR.
Lordship, after the objection, Lordship, it can be considered
No, but will it be LCR? Some amount of evidence has to be gone into.
after 4 weeks for objection.
Three for orders.
Why it has come for orders?
We had filed an
For suspension of
for
sentence for
suspension of
consideration.
sentence
Different
and
sentence.
bail, your lordship.
I had filed my objections last
Yes.
week. Perhaps it is on record. I could not check it because the file was up there.
No, the objection is not there.
I filed it on last week, no? I filed it on 28th. 28th, no, 28, I think.
28.
I have served him copies, but
Yes, I have
I
got-
think it's not on
The-
record.
Paper book is also ready.
Hmm? Okay.
Yes, lordship. Basically, today is the IA for bail and suspension of sentence. Basically, this case, your lordship, was under FIR was filed under section 4 of POCSO Act, your lordship. And it was basically the whole 12 years of conviction was given under section 6 of the POCSO Act. Your lordship, my first argument that 6 will not come here. But for that, I'll come to your lordship by showing that why 6 will not come. Even if 4 comes, your lordship, it's 7 years. Anyway, that is a separate issue. First, your lordship, the prosecutix version of the PW, I think prosecutix is PW2. I'll just show your lordship. From there, it seems to be very difficult to say that the petitioner has committed rape upon the it's, page 11 of the paper book. your
That
lordship.
live streaming may be stopped because it's a POCSO matter. The live streaming may be stopped. Perhaps he has stopped.
You're right.
It's a POCSO.
May I please, Lordship?
Yes.
Lordship, I filed this application, my lord, seeking leave, my lord. The husband has filed this application, my lord, for solemnizing second marriage, my lord. Since September 2020, my lord, they are staying separately, my lord. In this case, rule has been issued, my lord. My lord.
May I please, my lord? My lord, I received the copy of the IR just today. My senior has instructed me to pray before your lordship for filing the objection. A reasonable time may be granted.
Lordship, may kindly peruse the notice, my lord.
Just now. ma'am. Which notice?
Why copy has not been served, my lord?
But if this is the practice, then we'll have to deprecate it. We'll have to,
My lord, 3 days we have called in.
My lord, I have only received the copy. I have received the call from them only once.
My lord, it tries,
I
my lord,
did-
it
I
passed by
did-
the registry, my lord. It is,
And my
and
lord, I
before the
did,
registry, I also called my lord. In presence of the registry, my lord. I personally call him.
and
No, you see, these are things which we can't adjudicate. Number one,
Definitely,
you say that you called him and he did not receive it.
in presence of the registry, my
No,
lord.
no, it's okay. But in the presence of registry, that doesn't create a proof. You should have given a WhatsApp message and end of the matter. You could have produced the text that I have given a WhatsApp message to receive it. You can give an SMS and give a printout to the courtroom that I have given a SMS message. But you see, how do I prove that I called my brother and he did not pick up the phone? I may
Well,
have,
in the
I
first
may
day,
have,
they
no,
have
no,
received the
I
phone.
may have disconnected the phone before he receives it.
No, my lord.
You are saying no, but I am giving you the possibilities of yes.
Yes, ma'am.
Correct. So I can conveniently call my brother, disconnect it, and then give a proof that yes, I am calling him.
No, in presence of loudspeaker, I have.
These are not proof. These
Then
are not
only
proof.
registry
I
has
am not
passed.
taking evidence in courtroom as to in whose presence the call was made.
Before the registrar judicial, my lord.
No, but why you can't give a message and then end of the matter? WhatsApp today or tomorrow, day after tomorrow, you will get a double take.
my lord, I have also instructed him that he could have provided the PDF copy also. And the email also, the WhatsApp number is also there with the council. And I do admit the call was made, my lord, but then due to the paucity
No,
of
but
the
this
time.
is
Yeah, I have to give it
this
short,
is
my
a
lord.
practice we would not appreciate. You receive a call, it becomes your duty to
My lord, not once, my lord. 3 days, my lord. 26, 27, 28.
My lord, this IA has been filed just last week.
Definitely last week.
whatever be. When somebody is filing an interlocutory application, he has a right to move on the same day.
My lord,
Why 3 days?
my
You
lord,
can't you make a mention and have it taken up as an unlisted matter?
My
Don't
lord.
tell us the procedure. I've been to in that side for last 25 years.
my lord, no instruction was given to me when the call was made. No instruction was given to me, my lord. He did not, the advocate's clerk did not even mention which case was it. I do admit the call was made. He told me to receive a service copy, but then I was not aware which service copy was it.
You see, you want me to record this, duplicate it and send it to the bar council? You want me to do that?
No, my lord.
If a brother gives you a call, is he required to give you the entire encyclopedia there in the telephone? What is this? What is the writer? Who is the affidavit? Who has done? Who has said? I mean, which paragraph? What? You want the entire encyclopedia in the telephone?
No, my lord, that is my humble.
No,
submission,
don't provoke the court.
my lord.
So far as procedure part is concerned, sufficient indication of somebody is being filed is good enough for you to go and receive it. If you want me to record it, I'll duplicate it and send it to you to the bar council.
I beg your pardon, my lord.
Don't tell us because I've been there. I told you for last 25 years, we both have been there.
My humble submission, my lord, was only till that
Now give a copy. We'll take it up on
Already
Wednesday.
given.
I received the
We'll
call.
take it up on Wednesday, whether you file an objection or not. This is a practice we won't appreciate. If you want everything in an encyclopedia, you better tell when you are filing the wakalatama, you tell the court that this is how you are doing your practice. This is something we'll not appreciate. Absolutely no. This is where we can begin. You give your email address, you write it down in a piece of paper and give it to the court master. Give your email address and your WhatsApp number, give it to the court master.
My lord.
We don't want this practice to be repeated. You write it down and give it to the court master. We'll record it, your email address. For next service, you'll get a PDF copy, whatever she wants. Mr.
Hey, how are you, my lord?
A. Hawari, counsel for the applicant. And Mr. Your name?
I sing, man.
I Singh, counsel for the opposite party.
I for the petition. I'm for the petitioner.
You're opposite party here.
Opposite by here.
Next para. A copy of this interlocutory application has been provided to the learned counsel for the opposite party. First off, it appears that at the time of filing of this interlocutory application, call was made to the learned counsel for the opposite party to receive, which he has not done on the same day. Be that as it may, in view of the nature of prayer made in this interlocutory application, objection, if any, be filed within 9/8/2023. List on 9/8/2023. The next para. For subsequent communication, the learned counsel for the opposite party has provided as his email and mobile number as follows. Next para, list on 9/8/2023. We'll take a break and come back.
Gogoi. But my conviction was recorded against me, acting on the evidence of a child witness, claiming her, who claims that she was the eyewitness in this incident.
Yes.
My lord. My case is that the entire prosecution case based upon the testimony of a child witness whose veracity was veracity in the form that whether she understand the gravity, the seriousness of the deposition which she was going to give, whether she was being tested to that extent prior to recording of her evidence, that has not been done by the trial court. There is a high probability grave suspicions come in when the statement of the victim, the eyewitness, was recorded subsequently a couple of days back later, and no explanation of the lodging of the delay in the FIR was also there. The scene of offense are two scene of offenses, place of offenses. One is near the pond, but a dead body was recovered in the house. Every witness said that a child witness told that her mother was being hacked by me in the bank of the pond. She ran away. When she came, she saw that I was continuously hacking her. So that means the dead body should have been in the bank of the pond, but the dead body was recovered in the house, courtyard of the house. Nobody has explained whether someone brought the dead body back or retrieved the dead body to the house. There is no explanation. There is nothing of that sort. The victim, that is the husband, who was first assaulted, as alleged in the prosecution's case, he nowhere stated that it was me. But subsequently, my name came in. Second. Third thing is that prior to this incident, the deceased mother-in-law passed away. On that particular day, they were having the Sardha ceremony. I was present in the Sardha ceremony during that time, around 6:37, where the incident is alleged to have happened.
Yes.
My lord. Fourth thing, very striking, is that in the Caesar memo, which your lordship will, I will take your lordship's kind attention to that. In the Caesar memo, the dowel, which material object which has been seized, and one knife with a wooden handle, both have been exhibited as material exhibit 1 and 2. In a seizure list, there is no mention that those two weapons, alleged weapons, contain a strain of blood. My lord, neither the weapon of offense or the clothes of the offense deceased were sent for forensic examination. So in the entire case, there are a glaring example of missing link. The learned trial court acted solely on the testimony of the victim and the eyewitness and recorded conviction against me. If your lordship permits me, if I put it across like this,
Please continue.
my lord, I believe and I sincerely hope your lordship will appreciate that this is the final hearing matter. I have got the paper book through the digital thing, mail. My lord, I would like to go for an extensive hearing in this matter, but through virtually it is causing a little bit of hindrance, my lord.
No,
If
no.
your lordship,
If you wanted to take an adjournment, you take an adjournment in the beginning. No point
no, no,
wasting
my lord,
of time.
no, my lord,
We are
I
not
did not
trying-
wanted to.
No, no, you see, to hear a background of what is happening, what has happened, to give a few snippets here and there, and then to take an adjournment, that is something we dislike. You see, we are not here to waste our time. If you wanted to take an adjournment, you take it. Now you continue with the hearing. Once you
My
start, once you start reading the paper book, then you will say conveniently that you are outside, you can't argue the matter.
No, my lord, I will.
Comment the first half. Why you are taking me to even for reading 2 lines from the paper book? Why you are saying that this is my story, this is that? Why you are wasting the time of the court? You are out of station, your time may be of no value, but you don't think that for us also. If you take an adjournment, take it in the first time.
My lord, I could not take a adjournment because I could not circulate it later.
No, that's okay. But you see, what is the fun in spending 5 minutes and then saying that you wanted an adjournment? If you have started argument
sorry.
for 5 minutes, that means you are ready for the entire argument. You start and do it.
Then let it be kept up as a parted, my lord, if your lordship permits.
Started. We have. That's not the only thing we have to do. You think in our board that is the only thing we have to have on the board. Just keep
No,
on-
no, no, my lord. It's
No,
not
no.
like that, my lord.
No.
I'm sorry for the inconvenience, my lord.
If you take an adjournment, take it at the first blush. Don't
My lord,
make us-
then
don't make us read even.
kindly post the matter on Monday, my lord, 14th.
No, it goes after 2 weeks. On the prayer.
A date may be fixed, my lord.
It will come within 2 weeks, don't worry. It's not much matters we have. Both sides are duly represented on the prayer made by the unconscious of the petitioner, just after 2 weeks.
Obliged.
Pleasure.
No. Dr. B.N. Gogoi, amicus curiae. Notice दीजिए अपने का नोटिस हटा दीजिए Next item, we'll take it up. In the meantime, Dr. B.N. Gogoi. It's not in order. Okay. What's this? This paper. You're right. Second paper book. Will be Non-accused on call for the appellant. However, Ms. A. Begum Rani APP is present. Next para. The page 9. Page 9 is PW1. Not there. Seen the paper book prepared by the registry. Stop. It appears that the pages are not in order of the index. And the deposition of PW1 is not available. Stop. Accordingly, the paper book section said compare the contents of the paper book and
Lordship, if your lordship, page 19 of paper book, lordship, there's a evidence to the effect that in order to record a
no,
confession
not
statement.
not this matter. Earlier
This
matter.
one,
Earlier matter.
earlier one.
Huh.
I'm talking about Radhanath Kharai matter.
Yes.
Lordship, page 19 of the paper book. This is a lordship evidence to the effect. In order to record the confessional statement of the accused, SI Rupram Kolita made a prayer before the honorable court. The honorable court recorded a confessional statement. But in the paper book, I didn't find a confessional statement also, my lord. Whether it was exhibited or not, that I have not, could not find your lordship.
Okay.
Page 19 of the paper book.
Yes. Full stop. The learned APP has also pointed out that in page 19 of the present paper book, which is a part of deposition of PW5, there is a reference to confessional statement of the accused. Full stop. The said confessional statement also does not, is not a part of the paper book. Full stop. Therefore, the registry shall cause examination of the LCR in the paper book and make necessary corrections in the paper book.
My lord. They may prepare a supplementary paper book. They do so
No,
sometimes.
whatever the
they-
corrections I have said.
Right.
Not Ms. A. Begum, Ms. B. Bhuyan, Senior Counsel, APP State, assisted by Ms.
M. Chakraborty.
M. Chakravarti. Okay.
Obliged.
26. Yeah, please also. But I've convicted under figure 2 for regressive prison for life. With 1,000 fine and in default, simple imprisonment for 1 month. Under section 302 for murder of my brother-in-law. If I may place the FIR, madam, page 4 of the paper. I was arrested on the same day of the incident and since then I'm in custody for last 8 years, madam.
এটা জোর করবো। Yes.
The FIR is at page 4, madam, of the paper. The FIR has been lodged by PW6, madam.
Yes.
The date is 29/2015.
Humble submission is that about 3:30 on 29/2015, when my younger brother, Gokul Bhumis, was going to bring back the cattle from the seabed located in the middle of a paddy field in front of his house, neighbor Nitai Bhumis killed him brutally by hacking with a nagadao in the neck, as well as different parts of his body, without having any reason. I therefore request you to take necessary action against the aforementioned murderer upon investigation into the matter.
Yes.
If I may please his evidence matter, PW6 at page 18. He is Kalidas Bhumis. Accused Nitai Bhumis is known to me being my sister's husband. This is Gokul Bhumis was my younger brother. On 29/2015, my sister Shanti Bhumis, my wife of the accused, came to my house and informed me that the accused has killed our brother Gokul.
You're reading where?
PW6, my lord. The
Six.
informant.
Oh,
Informants. Page 18. Informant's evidence.
Huh.
The accused Nitai Bhumis is known to me being my sister's husband. Deceased Gokul Bhumis was my younger brother. On 29/2015, my sister Shanti Bhumis, wife of the accused, came to my house and informed me that the accused has killed our brother Gokul Bhumis. On this, I went to the place of occurrence, that is the field in front of the house of the deceased and accused, and saw the dead body of Gokul Bhumis was packed. By the time police had arrived there, I filed one written FIR. Exhibit 5 is my FIR, is my signature. On arrival there, my son Vittu Bhumis and his wife told me accused Vitai has killed Gokul Bhumis by cutting with a dao. My lord, he has heard from my wife. He is not an eyewitness to the incident, madam. In cross, he says,
Yes.
in cross, he says, I have not seen the incident of killing of Gokul Bhumis on my own. I was at my workplace. FIR was written in the police station by somebody else. I filed the FIR on being asked by police. I cannot say what was written in the FIR. My house is at a distance of about 1 mile from the place of occurrence. Deceased was a bachelor. For a few days, Nitai and Gokul, that is the accused and the victim, used to reside together. My son Bittu and Padmavati is wife of his son Bittu, used to reside at the land of Gokul, the victim. Gokul and Nitai resided contiguously. At the time of incident, Shanti, that is my wife, was with the deceased. She might have seen the incident. Shanti has informed me about the incident and accordingly I have reported the matter to the police station. Nitai has one married daughter. I cannot say whereabout of Shanti. My son and daughter-in-law are looking after the property. It is not a fact that to occupy the land and the house built by my son Bittu and the deceased, and deceased has made attempt. It is not a fact that for this purpose we disturb Nitai. He further states that it's not a fact that for grabbing the property on the date of incident, Gokul and Bittu physically assaulted Nitai, and for saving himself, Nitai has to use the dao on which Gokul might got some injuries. He is not an eyewitness. He felt my wife, the appellant's wife, informed him. She is Shanti. The other two facts that he has stated is the accused and the victim used to stay together. And then PW6 son and daughter-in-law used to reside in the land of the victim, Gokul. I placed my lord PW2 and 3, the daughter-in-law of PW6 and son. PW2, my lord, page 11.
PW,
Say the daughter-in-law of PW6. He has been protected as the eyewitness, my lord. Page 11, madam. Accused Nitai Bhumij is known to be being neighbor of my husband. However, we are related, madam. This is Bokul Bhumij is also known to me being uncle-in-law. On the month of Bhadra last month, at evening hours, while I was at the backside, a lot will mark this backside, my lord. She was at the backside of her residence, drying clothes. I saw that accused Nitai Bhumij has inflicted 4 to 5 dao blows to Bokul Bhumij and killed him. Said Bokul Bhumij went to Kathiani Bari to bring his cows, where the accused inflicted dao blows on him. When I rushed to save my uncle-in-law, accused chased me. No other person was present near the place. You also will mark this also. On this, out of fear, I got fainted. Bokul died for the injuries. Police came there and interrogated me. Police has also got my statement recorded in Sonari court. Exhibit 2 is my statement, and so on and so on. She refers to exhibit 2, my lord, which was recorded within 3 days from the date of incident, which is exhibit 2 at page 58, my lord. She has completely changed her statement here. At page
58.
58. She says, my name, age, and address are as mentioned above. Around 3:30 p.m. on 20/10/2015, should have been 09, 2000 September, 20th of September. I was at home and my husband was in the enclosed yard. There, in her evidence, she says, I was alone. At that time, I heard my uncle-in-law Bokul Bhumij screaming, save me, save me. He says, we ran, she and her husband, PW3, ran and stayed near our gateway. They didn't reach to the place of occurrence and saw that the accused Nitai Bhumij was helping my uncle-in-law with a dao in the paddy shaped bed located in front of her house. In her evidence, she says she was in the backyard, drying clothes. Here she says the incident occurred at the front of the house. The accused also chased us for hacking, and then we fled away. I hid myself at Shankar's house, and my husband went to inform the police station. In her evidence, she says, once I chased her, she fainted. Here she says, me and my husband, we ran from that place. I hid myself in some other place. Now PW3, madam, her husband, son of PW6, madam. Here's Bitu Bhumij, page 13, madam. 13, 1-3.
1-3.
1. Bitu Bhumij says, accused Nitai Bhumij is known to me, my maternal uncle. Deceased Bokul Bhumis is also known to me being uncle. About 2 years back on the month of Bhadra, on returning home from outside, there is no corroboration between PW2 and PW3. She said that once she said she was with me in the house. In evidence, she says that she was alone. Back in the month of Bhadra, I was returning home from outside. I saw that some people were standing and watching something. And my aunt, Shanti Bhumis, wife of Nitai, the accused, told me that my maternal uncle Nitai Bhumis has killed my uncle. And that's why I should not go there. But I went to the place of occurrence, that is the field in front of the house of the deceased, and saw that dead body of Bokul Bhumis was lying there. I saw injuries on his person. I also saw that my mama, Nitai, with a dao is crying. The peoples gathered there want me to flee away from there. And then I rushed to Abhaipur police station outpost and informed the matter to in charge. My wife also kept her concealed. Police came with him and apprehended Nitai from his house. Police released one dao from Nitai Bhumis. Exhibit 3 is the seizure list. Exhibit 3.1 is my signature. Material exhibit is so and so, which I recognize. Police also conducted inquest on the dead body. I saw injury marks on the head, neck, hand, waist, etc. Exhibit 4 is the inquest report. So and so is my statement. It should be signature. Police also got my statement recorded at Sonari Court. Exhibit 5 is my statement given in the court. Exhibit 5.1 and so are my signatures. In cross, he says that I have not seen the incident of killing Bokul Bhumis. Shanti Bhumis, my wife, appellant's wife, told me about the incident as she had seen the incident. I used to reside with Uncle Bokul Bhumis at his residence. The residence was built by Bokul, the victim. It is not a fact that the said house was built by Nitai and we have forcibly occupied the said house. I have no knowledge that for occupying the residence, there was quarrel between Nitai and Bokul. Nitai is the brother-in-law of Bokul. It is not a fact that for keeping me in the date of incident, Nitai objected to the matter to Bokul, and Bokul on this assaulted Nitai with a stick. It is not a fact that at the time of incident, I have also attempted to assault Nitai. He talks about his 164 statement, exhibit 5 matter, which is at page 66 matter. Page 66. My name, age, and address are same as above. Around 3:30 p.m. on 29/2015, I was working in the enclosed yard of my house. In his evidence, he says he was coming back from work. Here he says he was in his enclosed yard. My wife was preparing tea inside the house. There is a paddy seat in front. Both. The incident took place in front of their house. And our cattle were tethered there. My uncle Bokul, whom is the victim, went to bring back the cattle. Then I heard my uncle screaming as save me, save me. My wife called me aloud. I went towards and saw from in front of our gateway of our house that assault took place in the paddy seed bed. Nitai Bhumis was hacking Bokul Bhumis. The accused also chased us. I ran away and came to the police station and informed about it. My wife hid herself at Shankar Hazam's house. So as on 24/9/2015, PW 2 and 3 had a different story. They were together in the house. They had seen the incident from the front of the house. But when the evidence was taken, PW 3 completely vanishes. He's not at the place of occurrence. Only his wife is there, but the wife says she was in the backyard. And from the backyard, it cannot be seen since it was in the front of the house. The incident took place in front of the house. as can be seen from the sketch map, my lord. Page 68.
Page
68. A, B, and C are the tila, my lord. The others are seedbed for crops. A is the place of occurrence, which is a hillock located in the middle of the paddy field, and so and so. There are other two hillocks nearby. The house of deceased Bokul Bhumis is situated in hillock B. So PW 2 and 3 were residing with the victim Bokul Bhumis in hillock B. Since he is not married, his nephew and his wife stay along with him. That is PW 2 and 3. The house of the accused, Nitai Bhumis, is situated in hillock C. In the nearby area extending up to 1500 meters, there is no human habitat. There is wetland paddy in the surrounding of the place of occurrence. So incident took place in front of house number B. It could be seen only from the front side, not from the backyard.
No, this we can't say when it is in a hillock.
The incident took place in the seedbed, not in the hillock.
Which is
They
the
have
hillock,
written it-
my lord, place of occurrence as per page
They have
69.
stated
No, page 69, it says, note A is a place of occurrence, which
Place
is
of
a hillock.
occurrence. Right. Right.
So if it is in a hillock, we can't just say that whether it can
Cannot be
be
seen.
seen, cannot be seen.
I'll place that.
It says storyline in 164 is different. That is a fact.
Now they have brought in my wife also. That she has seen the incident, she informed PW3, and that's how he filed the FIR. And PW6. She has been, her statement has been recorded as CW1. It should be CW2, page number 25. My wife. At page number 24, they also say CW1. There are two CW1. In the judgment, it has been clarified that Shanti Bhumi's evidence should be CW2. In the impugned judgment, it has been clarified. Page 25, ma'am, Shanti Bhumis. She says, accused Nitai Bhumis is my husband. Deceased Bokul Bhumis was my younger brother. On the date of incident, I was at my matrimonial home at Abhaipur, Rangapathar Gaon under Sonari PS. On that day, at the field, on seeing a gathering and learned that my husband killed my brother. After some time, police arrived there. I saw cut injury marks on the neck of the deceased. In cross by the prosecution, she says that I have seen the incident of cutting my brother by the accused on my own. Cross by defense, madam. Bokul Bhumis was a bachelor and used to stay in our residence. The victim used to reside with us for about a month. Thereafter, Bittu, that is PW3, son of my elder brother Kalidas PW6 and his wife Padma PW2, started living with Bokul Bhumis, and as such, Bokul left our house. The house was constructed by Bokul, the second house. Thereafter, Bittu forcibly possessed the house of Bokul, PW3. On this, Bokul had quarreled with Bittu and his wife, 2 and 3. In my matrimonial home, I lived with my husband. My daughters were married. After this incident, police found my husband at the residence. I have heard from locals regarding killing of my brothers, but I cannot say their name. Police battalion also informed me this while encircled our residence. B2 was present when police arrived there. I have not stated to B2 that Nitai has cut Bokul. So she denies that she has informed PW3. After this incident, B2 also grabbed my house and did not allow me to stay there. Presently, I am living with my daughter. PW3 initially says that he was there. Evidence part, he vanishes. PW2 and 3 says that she was alone. He is out of the picture. To say that only the appellant was there, who could have killed the victim.
Do you have the background how this CW came to depose?
After 313 statement, after my 313 statement, the judge felt that two witnesses should be called. Civil 1 and Civil 2.
After 313
After 313, and then again, my re-examination on the
re-examination. Yes.
Now, may please paragraph 22 of the impugned judgment to show how the trial court has appreciated the evidence of the CW2,
Page.
page 43. CW1 ought to have been numbered as CW2, Srimati Shanti Bhumis, wife of the accused and sister of the deceased. In her evidence deposed that on the date of incident, while she was at her matrimonial home at Abhaypur so-and-so, on that day at the field, on seeing a gathering, she came to know that her husband killed her brother. After some time, the police arrived there. She saw cut injury marks on the neck of the deceased. In her cross by defense, deposed that Bokul Bhumis was a bachelor and stayed at the residence of Nitai Bhumis for about a month. Thereafter, Bittu, son of her elder brother Kalidas, and his wife Padma started living with Bokul Bhumis. And as such, Bokul left her house. The house was constructed by Bokul. Thereafter, Bittu forcibly possessed the house of Bokul. On this, Bokul had a quarrel with Bittu and his wife. In her matrimonial home, she lived with her husband. After this incident, police found her husband at her residence. Now she will continue after the break. One.
We are proposing that we will continue for this matter after lunch,
My lord,
but we will not take up other matters.
Lordship, what about the
Other man,
other one?
19 years. jail.
19 years in jail, my lord.
Ah,
I've
that-
gone
that-
through
that
it.
also,
There are lordship evidence, confession statement of
ah,
the
that
accused
also we'll take it
person,
up.
my lord.
That also will take it up.
Lordship, I beg to mention item number 25.
You were not there.
Lordship, I beg to, my humble submission before this honorable court, I have seen the paper book, your lordship. If lordship permit us to give the 161 statement, confession statement have not been included in the paper book. So I have.
I've seen that. I'm better note. We'll ask the registry to correct it.
Lordship.
Okay.
And if
Dr. B N Gogoi, item 25. Okay, we continue.
My lord.
মই এইটো চফ্ট কপিটো দিম বুলি ক'লো মই। মই যোনকেইটা মেটাৰ ডিক্লেয়াৰ কৰিছোঁ
বহিব ক'লে মই এইটো লগত নেক্সট নলয় বুলি ক'লে টিভিটো বহিব দুটা আইটেম ল'ম বুলি ক'লে কন্টিনিউ হ'ব নেক্সট আৰু 5 কিলো ল'ম বুলি ক'লে
বিচাৰা নাই আপুনি এটা কাম কৰিব
নলয় আমার কলম দিবা
আপনার এগেছে যেগুলো আসলে এডিশনাল পিপি নিয়ে
মই এইটো দিম চ' তেওঁ কোৰ্টে কৈছে কি আপুনি এইকেইটা লিখি দিব কোনকেইটা মিচিং আছে আৰু এইকেইটা তেওঁ
যোনটো আছে সেইটো দি দিব লাগে এইটো দি দিয়া দিব এইটো দি দিয়াচোন এই ভণ্টিকেইটাক দি দিয়া এইটো 26 চলে 27 টো দিব পাৰো 27 লাগিব 27 এইটোৱে ৰাঙাটো দি দিয়া দিয়া ৰাঙাটো দি দিয়াচোন
ক্লিয়ার হয়েছে এই প্রস্তাবটি লিখিলেন এই উকিলটোৰ নাম DK দাস মানে 11ৰ পৰা 8 লৈকেতো তাতে অপোজিট পাৰ্টি উকিলটো কৈছে তেওঁৰ নাম DK দাস D for Delhi DK দাস senior advocate SC নিয়াবে okay order to 13 14 15 16 and 18 percentage to
এইকেইটা দিছে
এইকেইটা আছে নে এইকেইটা তো এইকেইটা পেপার
আমার থেকে না একবার দিয়ে দিছে 4 weeks
এইটো আপনার 4 weeks আহিছিল
মোৰটো 4 weeks পিছত আহিব পেপাৰ বুকটো ৰেডি কৰি কিনে 2 সপ্তাহৰ ভিতৰত দিবলৈ কৈছে এইটো লিষ্ট হ'ব 4 টকা।
আপুনি পাইছে এইটো কিন্তু
ঘটনা হ'ল এইকেইটা কি কৰিলে
কিতাপ আপুনি অৰ্ডাৰ বা চৰ্ডাৰ বনাই দিব এইবিলাক 9 এপ্ৰিল ষ্টক পাইছে কিন্তু আমি যদি ভাবো যে CIS কৰিব লাগিব
দিব লাগিব
ঠিক
এতিয়া তাইকটো এইকেইটা দিব লাগিব
এইকেইটা বাদ দি বাকীবিলাকৰ নাম এপিয়াৰেঞ্চ আছে
আৰু সেই ৰিজাৰ্ভ পৰীক্ষা হ'ব গোটেইকেইটা আৰু এইকেইটা কেৱল নাম আহিব 13, 14, 15, 18
এতিয়া আপুনি বা কথাটোৰ পৰা উত্তৰটো ওলাইছে বাৰু এই যিকেইটা মানে এপিয়াৰ হোৱা এইকেইটা বাদ দি সেইবিলাক নাম এপিয়াৰেঞ্চ actually delete wrong method. মই আমি দি দিম ষ্টেনগ্ৰাফাৰ পৰা
হ'ব যদি তেনে এতিয়া এইকেইটাত মাৰিব লাগিব 13, 14, 15, 16, 18 এইকেইটাত মাৰিব লাগিব
13, 14 আপোনাৰ কাৰণে এই মই আপোনাক সুধি খোজা কথা মই আপোনাক কিছুমান পেপাৰ যিটো বনাইছে তাতো ছাৰে অৰ্ডাৰ দিছে সেইকেইটা এক্সিবিটটো এনক্লোজ কৰি দিব লাগিব আৰু কোনকেইটা এক্সিবিট এনক্লোজ কৰিব লাগে সেই বিষয়ে মানে আপোনাৰ মেইলটো তাত পঠাই দিছে মই দি দিম এইখিনি বুজিব পাব ষ্টেনে জানে মানে প্ৰচাৰক কৈছে মোক মেইল কৰি দিব হা
এই ছোৱালীজনী দিবা আছে ফাইলকেইটা ওলাই দিব লাগিব তাই দিবাচোন সেইখন দি আহিবা যদি ফাইল এটা লাগে পিছত ওলাই দিলে হ'ল কেইটা ফাইল দিছা গোটেইকেইটা ফাইল দিছা এই চিৰিজটো এটা গৈছে চিৰিজটো এটা গৈছে যদি কিবা লাগে আৰু লাগিলে দিম তাই লিখিলে হ'ব লাগিলে দিলে হ'ল কৈছে ভাত খোৱাই দে
তুমি অলপ সোনকালে আহা, কাৰণ 2টা বজাত মেটাৰ আছে। একদম তাৰ আগতে আহা।
কোনো লাভ নেই। খং উঠাই কিনে ওলাবি। আহি যাব লাগে। এটা হৈ গৈছে। 15 minutes? Is it not 15 minutes? Sir? আপুনি যিখিনি ক'ব লাগে সেইখিনি সাৰাংশ কৰি কিনে কৈ দিছো বাকীকেইটা উইটনেছ এনে ওপৰৰ পৰা জানো তাতে সেইকেইটা এইকেইটা হয় চিৰিয়েল উইটনেছ হয় কিমান মেটেৰিয়েল
Yes.
that Shanti Bhumi's wife of so and so
Hmm.
deposed that on her date of incident, while she was at her matrimonial home at Abaypur so and so, on that day at the field, on seeing a gathering, she came to know that her husband killed her brother. After some time, police arrived there. She saw cut injury marks in the neck of the deceased. In her cross by defense, deposed that Bokul Bhumis was a bachelor and stayed in the residence of Nitai Bhumis for about a month. Thereafter, Bittu, son of her elder brother Kalidas, and his wife started living with Bokul Bhumis. And as such, Bokul left her house. The house was constructed by Bokul. Thereafter, said Bittu forcibly possessed the house of Bokul. On this, Bokul had quarreled with Bittu and his wife. In her matrimonial home, she lived with her husband. After this incident, police found her husband at her residence. He heard from the locals regarding killing of her brother, but she cannot say the name from whom she heard. She did not inform Bittu and Nitai about conflict. After this incident, Bittu also grabbed her house and did not allow her to stay there. So she came to know from others. She was not an eyewitness. And rightly so, how I have been asked in my 3-on-3 statement, you'll also will see. After her statement was recorded at page 33, madam.
Thirty-three.
33. This is re-examination after her statement, madam. Question number 4, madam. Srimati Shanti Bhumis, your wife, in her evidence deposed that deceased Bokul Bhumis was her younger brother. On the date of incident, at the field on seeing a gathering and learned that her husband, that is you, killed her brother. What do you have to say? And question number 5. CW1 also deposed that after some time police arrived, she saw cut injury marks on the neck of the deceased. The question that she has seen me killing him has not been asked to me.
If you see in the judgment,
Madam.
I think the court is relying more on the evidence of PW2. Yes.
And regarding that, my lord, where a place of occurrence, my lord, PW9 had prepared the sketch map. In his statement, he says at page 22, my lord.
Yes.
PW9, my lord. The
PW9.
Page 22. Page 22.
Page
22.
22.
Second paragraph of his evidence. Last two lines, second paragraph, madam. I have drawn the sketch map of the place of occurrence. Exhibit 6 is the said sketch map. And in cross, he says, defense cross by defense, sixth line. Sixth line, madam. The place of occurrence is a paddy field. Although he has drawn the sketch map and marked the Kida as a place of occurrence, but he in his statement himself says that it is the paddy field. The prosecution has relied on PW 4, 5, and 8.
Because from what you have read,
Madam.
this CW1 refers to the place of occurrence at paddy field.
CW1.
CW1.
CW1 does not say, my lord, anything.
CW1
Page 25.
25. Yes, page 25,
Madam.
second para. On that day
On that
at
day-
the field, on seeing the gathering, I learned that my husband in the field.
In the field.
So
Paddy
therefore the place of, that will be the place of occurrence where she saw the people gathering and saw
People were
the.
gathering there.
Ah.
But whether the actual incident took place there, she doesn't say. She said the people were gathered there in the field. And on query, they told me that my husband had killed my brother.
Hmm.
But the IO clearly says that the place of occurrence is the paddy field.
Paddy field. And
This
the
is in corroboration
PW2 says that it is in the front of the house,
in front of.
which
the house.
is again hillock.
No.
Lordship,
At
Your
160.
Lordship, in space 69, sketch map, the description is given. A is the place of occurrence, which is the hillock located in the middle of the paddy field of Rangapatha ward number 1.
Huh.
So in the hillock, paddy field is there.
No.
Log is
You
in
see,
between the paddy
One-
field.
what I understand is that
My lord.
Salitoli has to be a low-lying land.
My lord,
If it is a paddy field,
yes,
then it has to be
Has to be
naturally a low-lying area. Salitoli, that's because that is ingrained in us from that land, what you call, entries in the land records.
yes,
It's called Salitoli means it's a low-lying land where the
Yes,
paddy
yes.
is, paddy is normally is not
On a
sown
sown in
in
the
a hillock.
hillock,
Even
Yes.
if it is done in a hillock, then they have to do it like they do it in Arunachal Pradesh
Yes,
or
yes.
in
and this
Mizoram. They have
pineapple,
to,
pineapple cultivation.
no, not that cultivation. That is called, yeah.
They cut it,
Uh,
make a
They,
slab and then.
they cut
Jhum,
the
jhum.
land, no, not Jhum. Jhum is burning of the land, not that. They will cut it and they will make it stepwise.
Yes.
Terrace,
or
terrace
terrace,
farming. huh.
Okay,
So that is
Yes.
done in Arunachal and this is
Yes.
also done in Mizoram and other places. Terrace,
hilarious, yes, ma'am.
it is done in that way because if the water can't retain, the paddy will not be there.
I know.
Now the sketch map has been prepared by the IO and he
By the
himself
IO.
says that it is the paddy field.
Hmm.
Now I'll place three more evidence, madam, witnesses, PW 4, 5, and 8. They've been placed reliance for seizure of the murder weapon, as well as for bringing the body, that body from the paddy field. If I am placed PW 4, my lord. He has denied about the seizure of the murder weapon, madam. I'll place
PW3,
Oh.
that Bittu Bhumis,
bituminous
he also places the dead body in the paddy field.
paddy field only. He is also one of who carried out the dead body.
Huh.
Page 15, madam.
Here also it is paddy field.
Paddy.
So the murder took place in the paddy field. There's no doubt about it.
So there,
Your PW4 says, police came to a village and requested us to pull out the dead body from the water donga in the field.
in the field. Mohan Bhakti and Bitu Mumis were also with me, accused Nita and so and so. This we pulled out the dead body to the plain area. Police also asked me to sign on some paper. I cannot say anything about the seizure. So he has denied about the seizure of the dhow, but he has said that it was in the paddy field. Madam. Then PW 5, madam, next page.
Yes.
He is also a co-villager. This is accused Nita Bhumis is known to me for being a co-villager. This is Bokul Bhumis is also known to me being villager. Bokul was the brother-in-law of the accused. On 29, 2015, police came to our village, and on this, I, along with few others, went to the police Rangapatra Gaon in a field. On seeing the dead body of Bokul, requested us to pull out the dead body from the water in the field. So paddy field. I, along with Bittu, Tanti and Bittu Bhumis, where we also with me, the PW 3 and 4, madam. I have not noticed for injuries, if any. So we could not see any injury on the body of the victim. On this, we pulled out the dead body to the police station in a food cart. Police also conducted an inquest on the dead body. The IO himself conducted the inquest. There is no record that he was authorized to do that inquest on record. And then so Nitai, accused Nitai handed over one dhow to police. Police seized one dhow from Nitai Bhumis. So and so is my signature, the seized dhow, which I can recognize. Now, if your lordship will see the exhibit 3, madam, which is at page 60.
Page
60.
60.
Date and time of seizure is 29, 2015 at 5 p.m. On the same day at 5 p.m. FIR says incident took place at 3:30. The seizure is one Naga dhow. The length is about 2 feet, including the handle. Wire is seen wrapped around the bamboo handle.
As per the FIR,
As per the FIR, 3:30,
3:30,
time of incident.
Caesar,
Time of
Time
incident.
of incident.
incident.
And at the 1.5 hours, this dhow was seized. But they failed to see any blood marks there on the dhow.
Because if you see,
My lord.
you have CRPC, 174.
174. If he is authorized, he can do. If the police
No, it
officer-
says circumstances. When the police officer in charge of police station, some other officers specially empowered by the state government, they have received information that so and so, a circumstance, so and so. He shall immediately give intimation
To the
thereof to the nearest executive magistrate empowered to hold inquiry, unless otherwise directed by any rule so and so,
by the
or
state
by general special order, shall proceed to the place where the body of the deceased person, in the presence of two or respective individuals of so and so, shall make an investigation. Correct. So you're right, there has to be empowerment.
So that has not been placed on the.
Yes, Ms. Bhunia, you'll have to show us
Lordship,
compliance of section 174.
yes.
For conducting the inquest by the I.
Lordship, 175, if I'm not wrong.
74.
Yes, my lord, 174. It's relating to police report, inquiry, report on suicide, etc. Your lordship,
Correct.
yes,
You see, here it says
yes,
a police officer is required
yes,
under 174 after the incident. If he finds a dead body,
yes,
then he should report immediately to the nearest executive magistrate
yes, for inquest,
for inquest.
yes,
But it says that if the officer is empowered,
yes,
then he can do it himself.
yes.
In the
Whether he
middle, you'll
was
find
empowered, I'll go through the records, whether he was empowered. to-
it's not there.
whether- Yes, oh, it's not there.
No evidence has come that he's empowered.
Yes,
So Mr. Prasad is questioning the authority of the IO
IO to conduct the.
to conduct
inquest.
the inquest. Because if that goes,
My lord,
then it will have some what you call impact on the in the manner in which
prosecution story.
no, in the manner in which the investigation
Big
proceeded.
investigation is done. Lordship,
I'm just
even if your lordship discuss the inquest report, my lord, the evidence of eyewitnesses still remain, your lordship, the evidence of PW 2 and 3, my lord,
no, you see, if the inquest goes,
yes,
the first what you call assessment of the injury,
my lord,
how the body was placed, how the body was found,
my lord,
that goes.
my lord,
So therefore, now you are only dependent on the evidence of the witnesses.
as well as the doctor, your lordship, doctor's evidence. Your
Yes,
lordship has to take it.
but how do you do the corroboration? You see, in the inquest,
My lord,
let us say in the inquest, you find that there is a what you call assault of thou on the hand.
my lord,
Correct.
my lord,
In the postmortem report, it is not there. Injury in the hand is not there. Let us say. Then, in the cross examination, when the corroboration or is questioned in the cross examination. So number one, if the inquest itself goes,
my lord,
the first position of the body, which was in the manner in which it was found lying,
my lord.
that one part goes. So therefore, there is only a second part which can establish whether there was a murder or not. It is
Lordship.
you are absolutely right. If the inquest report goes, it is not so fatal.
My lord. So some cases we find, your lordship, where while doing the criminal appeals, inquest is also not done. The magistrate who conducted, the circle officer who conducted the inquest, he was not examined.
Hmm.
The inquest report is not exhibited. So all these, there are lapses in the prosecution story. But even if that lapses are not fatal, if the prosecution witness establishes the case beyond all reasonable doubt, my lord, and stand on its own legs, it not be fatal to the prosecution case.
Okay, you have to address that.
Right.
And yes,
PW 8, my lord. Page 21.
Yes.
PW 8, page 21. He is also witness to the seizure and he also helped the police to bring out the body on the battlefield. He says, accused Nitai Bhumish is known to me being co-villager. This is Bokul Bhumish is also known to me being villager. Bokul was the brother-in-law of the accused. On 29 to 2015, police came to our village and requested us to help them in recovery of the dead body of Bokul Bhumish from the paddy field. On this, I, along with Bittu Tanti, Mohan Bhakti, Shibu Bhumish, went to the police went with the police to Rangapathar Gaon in a field. On seeing the dead body of Bokul, requested us to pull out the dead body from water in the field. Out of fear, I have not noticed the injuries, if any. PW5 also says he has also not seen any injury on the body. He also says that I have not noticed for the injuries, if any. Thereafter, we brought out the dead body to the police station in a pool cart. Police also conducted inquest on the dead body. Exhibit 4 is the inquest. And as mentioned, I saw the accused Nitai was sitting in the paddy field. In cross, he says, which I like your lordship to mark, the dead body was lying underwater and was tied in a blanket. The dead body was lying underwater and was tied in a blanket. Where was the occasion? Page 21, madam. In cross, the dead body was lying underwater and was tied in a blanket. I signed the inquest in the field. I cannot say why my signature was taken and so on. Where was the occasion for me to tie him in a blanket? If I hit him, he fell down. And my conduct, my lord, I was there in the same place. I didn't move out of the. And regarding that seizure, that they had seized the dhow from me. In 313 statement, 313, I was asked that question, madam. At page 27, madam. Question number 12. Page 27.
Yes.
Question number 12. PW3 also deposed that police seized one dhow from you. Exhibit 3 in the seizure list. So and so, which he can recognize. What is your say? He says, appellant, on being asked to bring the dhow, I have handed over the same to the police. it was my dog. I just handed it over. Whether the same dog has been used for killing has not been proved. In the seizure list, they do not find any blood mark on the dog, nor has it been sent for forensic.
Yes.
My defense is in question number 44, page 31, 313 special. Page 31, question number 44, whether you have anything more to say in the case and the evidence. I have looked after the deceased since last 2 years of the incident. Prior to this, he was with me for 5 years. He was deserted by his brother. He had some quarrel with Bittu Bhumis, Mangal Bhumis and Kalidas Bhumis on landed property acquired by the deceased Gokul Bhumis. Bittu, on this matter, Mangal, Bittu and Kalidas attempted to kill Gokul in the month of Aghan. I have mediated the matter. My story is that PW6, elder brother, and his son had some dispute with the victim, who was actually staying with me for last 5 years. And for the last 2 years, they have been living separately with PW2 and 3. They have a dispute regarding that property. They have even tried to kill him in the month of Agon. I have settled that matter. It could have been any person who could have killed him. And that's how I say that I'm innocent. I have been falsely implicated in the case. I cannot say how Gokul Bhumis died. Now, after my wife has made her statement, they have taken the property of the deceased, 1 tila. My property also has been taken over by them. Since I'm in jail, my wife has been pushed out from that place. My wife says. Now, PW2, 3 and 6 are enjoying that property. PW2 and 3 have changed their statement from 164 in evidence. PW3 goes missing. Initially, he was there, now he's not there.
But still, Mr. Basar, please come to page 25. The CW1, in the cross-check prosecution, she is again reiterated, I have seen the incident of cutting off my brother by the accused on my own.
But this has not been appreciated by the trial court.
Hmm?
It has not been appreciated by the trial court. Neither this question has been put to me in 313. And it is contradictory to her own statement. If she has seen herself, she will be telling the other people. The other way she says that when I saw a crowd in the field, the people told me that my husband has killed my brother. It is self-contradictory.
Correct, you are right.
So the only witness is PW2. What is our intention in changing her statement from 164 to her evidence? Is she trying to save her husband, who had a dispute with the victim?
No, the dispute with the victim is not culled out from the evidence of the, because for that, no evidence was there. Yes.
In the case in hand, Your Lordship, there are two eyewitnesses to the occurrence. Padmavati Bhumis, the PW2, and B2 Bhumis, who happens to be the husband and wife. Apart from that, CW2, my lord, Shanti Bhumis, who is happens to be the wife of the accused person, my lord. Lordship, if Your Lordship comes to the evidence of PW2, my lord, at page 11. He has specifically narrated the
Just-
incident, Your
just a
Lordship.
moment.
Page 11. Lordship, may I read it slowly? Accused Nitai Bhumis is known to me being neighbor of my husband. This is Bokul Bhumis, also known to me being uncle-in-law. On the month of Bhadra last month at evening hours, while I was on the backside of my residence drying clothes, I saw that accused Nitai Bhumis has inflicted 4 or 5 dow blow to Bokul Bhumis and killed him. Said Bokul Bhumis went to Kathalani Bari to bring his cows where the accused inflicted dow blow on him. When I rushed to save my uncle-in-law, accused chased me. No other person was present near the place. On this, out of fear, I got faint. Bokul died for the injuries. Police came there and interrogated me. Police also got my statement recorded on Sonari Court. Then in the cross minor, accused Nitai is my maternal uncle-in-law. Bokul Bhumis was bachelor and used to stay in the residence of Nitai Bhumis as domestic helper for long. Accused has Nitai has his wife. His daughter was married. I cannot see why Bokul Bhumis left the house of Nitai Bhumis. I have no knowledge of any quarrel between Nitai and Bokul for leaving the house. While going to bring back the cow, Bokul took one lathi in his hand. No dow was in his hand. I have not seen any quarrel between Nitai and Bokul at the place of occurrence. It is not a fact that at the time of giving statement before police, I have stated about some quarrel between them. It is not a fact that after the quarrel, this is Bokul tried to assault Nitai with lathi. It is not a fact that we used to take the service from Bokul and for this there was quarrel with us. It is not a fact that to grab the property of Nitai, my husband has concocted this first case and kept him in jail. Then, Your Lordship, B2 Bhum is PW3, who is the husband of PW2, my lord. Please.
No, but first of all,
My lord.
the same point which Mr. Prasad has raised. You see, number one, she's in the backside of the house.
Yes,
If this is a paddy field, then it will not be in the hillock.
yes,
And if the dead body is in the paddy field, then perhaps Mr. Prasad is right. From the backside, you can't see the field
yes. There's a
because
possibility.
you come to that
Sketch map, my lord.
sketch map.
Page 68.
He's lying in the middle.
He was lying on the middle.
Yes, and the
And
house.
paddy, yes,
House of the accused is in Hillock C. This
Nitai Bhum is situated.
Nitai
Hillock
Bhumi is
C.
in the actually Nitai Bhumi, she was in her house,
No,
She
Lordship,
was staying in the house of Bokul.
Bokul, Hillock B.
Hillock B.
Hillock B.
Hillock B.
Paddy field. From the backside, the middle of a paddy field. Is it possible to say? This. No, not like that. He's in the backside. This is. Backside. Like we don't know the position of the house where she was there. Backside means this is backside and this is backside. Correct. Description is. Okay.
No, Lordship, since the height of the hillock is also not mentioned, my lord. Whether the height, where the,
No, and my brother is also right.
my
My
lord.
brother is. You come to that inquest report, that is page
In case they 62.
62.
Right.
No, not that, the sketch map,
Sketch by
Sketch map
68.
68. No, 68,
My lord.
you look at the position of the house. B.
B, yes.
Now, the question would be, which is the backside?
Now, if 164 statement is considered, 164 statement of PW 2 and 3, they say they had to come up to their front side to see what was happening.
Where is that?
At page 58, my lord,
58.
is PW 2. Relevant is at page. Relevant is at page 59. We ran and stayed near a gateway and saw accused whom is so and so with a dog
They had to come in the front.
on the front.
Yes, so it
So it
is
is at the back side
164.
of the house.
She saw that after reaching the gateway also, she and her husband witnessed the occurrence, my lord. And your lordship considers the injury part, it's not that only once the accused had. A number of injuries are found. It is not a single injury is given and he fled away or something like that, my
No,
lord.
no, there's a change in storyline.
My lord,
What Mr. Prasad is hinting when he's referring to 164,
my lord,
juxtaposed with the statement made in the examination in chief.
my lord.
He's trying to suggest that there is a change in the storyline. Here, they are there in the
Yes,
house,
yes,
Both of them.
and this is not supported by their examination in chief. That they were in the house.
yes.
She was in the backside of the house. And in this 164, Mr. Prasad is pointing out that they could have seen the incident only when they come into the front side of the house. Therefore, standing in the backside and looking at the incident is out of question.
Your lordship,
Getting the
I
point.
understand, but your
Yes.
lordship, I mean to say, my lord.
Hmm.
They might have seen one occurrence like hacking once from their back. They came forward. Once they reached this courtyard the gateway, they saw your lordship, the accused giving other blows because there's not only the single blow, the number of blows were given to the deceased, my lord. If your lordship considers the postmortem report.
And the fact that the incident took place in front of the house is also corroborated by PW6, my lord. Father of PW3.
You
PW6.
see, they came into the gateway and saw the accused Nitai Bhumis was hacking uncle-in-law with a
Yes,
dao
put it out.
in the paddy seat bed
Lordship,
located in front of the house.
yes,
The accused also chased us
it
for
from hacking,
and
some
then so and so.
enmity because they used to have quarrel,
No, that is okay.
yes.
But you see, from that side, he came here and then these people started to run. And there's a distance between the two.
It was a small hillock, small village area, your lordship.
I don't know. Hmm.
This sentence.
She was not in the house. She was not in the house. She was in the backside of the house. It is in English. This is the original one. Same thing. Same thing. Huh. Only. Because here. This is. I think if you say they will be wrong.
And the fact that the incident took place in front of the house of the victim is also corroborated by PW6, father of PW3. He says, on this, I went to the place of occurrence, that is the field in front of the house of the deceased and the accused, and saw that the dead body of Bokul Bhumis was packed.
And the evidence of CW2, who is the wife of the accused person, and she deposes against her own husband. My lord. And she has reported PW6 also. Who is a brother-in-law, Kalidas Bhumis. Shanti Bhumis, wife of accused, came and informed that accused has killed.
She was also the sister of the
Deceased.
Yes, they are related to both the sides, my lord. On one hand, husband, and like on the other hand, related from both the sides, your lordship. And lordship, there might be two parts. Unless these two witnesses won't come to their own courtyard or on the gateway, unless they have witnessed the incident. Because she was drying the clothes, my lord. Other one was busy with, like husband was like in the adjacent, like in the courtyard, it's in the nearby area,
It's not there.
my lord.
There is a change in stand from 164 to 1.
When it comes to the stand of the husband and
My
wife,
lord,
PW 2 and 3,
my lord.
their stand is changing from 164
Lordship,
to.
if your lordship permits, may I see 161 once?
Yes. 161.
One, my lord. Was there person before the police?
Not a part of the report. NCR.
It's in the LCR image.
Yes.
My lord. And if your lordship considers the
The husband is B2.
husband is
Husband is
B2.
B2.
Two police. There are two victims. PW3 and PW4.
No, B2 Tanti.
Tanti. I'm husband
Oh,
is
B2 Bhumis. Yeah, B2 Bhumis.
I'm.
No,
I'm
no, no,
retired.
no,
B-
no. Husband is B2 Bhumis.
B2 and Padmavati,
Padmavati Bhumis.
husband and wife.
Hmm.
And Shanti is the wife of the
Huh.
deceased.
Huh.
Lordship, if
Yes.
your lordship look into the evidence of
I'm
Shanti
sending you
police,
this.
may I see the
I'm sending you. I have flag marked.
my lord. Should I read it? Your lordship?
But just see,
My
and tell us. Hmm.
Lordship, I'll read the relevant portion only. আজি ইংৰাজী 20/9/2015 তাৰিখে অপৰাহ্ন 3:30 মান বজাত মোৰ খুৰাই তেওঁৰ ঘৰৰ ওচৰতে ওখ ঢিপটোত এৰাল দি থকা গৰুটো আনিবলৈ যাওঁতে খুৰাৰ ঘৰৰ কাষতে থকা আছামিচি নিতাই ভূমিজে উক্ত স্থানত হাতত এখন নগাদা লৈ হাজিৰ হৈ কোনো কাৰণ নোহোৱাকৈ মোৰ খুৰাক আক্ৰমণ কৰে। So they have in the 161 they have named specifically.
No, but now their location is not there.
Lordship, may I see? মোৰ খুৰা বকুল ভূমিজে বেটি মোক বচা। This is the মোৰ বৌ বেটিহঁতৰ পলাই যা বুলি চিঞৰি উক্ত স্থানতে বাগৰি পৰে। ইতিমধ্যে নিতাই ভূমিজে দা লৈ আমালৈ খেদা মাৰি অহাত Lordship, place of occurrence is not mentioned.
No, but from this statement, there's one thing which has come out.
My
Number one, that the victim
Yes,
must have seen the lady and then shouting that you saved me.
yes,
That means visually they had seen each other.
yes.
So both the statement goes under 164 as well as the statement under before the court that they came out and saw the incident. Although contradictions are not found in the cross-examination, but
Why not?
we are just trying to understand the situation.
Lordship, there might have been some dispute regarding as the deceased built the house, and so I wanted to take your Lordship to the evidence of CW2 once, my lord. Page 25, my lord. Last line. After this incident, last line, page 25. After this incident, Bitu also grabbed my house and did not allow me to stay there. Presently, I'm living with my daughter. Lordship, dispute may be because evidence hasn't come out, although they have implicated the accused person, my lord. Lordship, there might be some dispute as regards my land and the building, the house, my lord. Because the deceased has constructed the house and thereafter he left the house, my lord. As this husband and wife, PW 2 and 3 came and lived with him. So he left the house, my lord. Lordship, third line, crossed by defense. Bokul Bhumis was bachelor and used to stay in our residence of Nitai Bhumis for about 1 month. Thereafter, Bitu, son of my elder brother Kalidas, and his wife Padma started living with Bokul Bhumis. So this one is PW 2 and 3. Bokul Bhumis, and as such, Bokul left her house. The house was constructed by Bokul. Thereafter, said Bitu forcibly possessed the house of Bokul. On this, Bokul has quarreled with his Bitu and wife in my matrimonial home. But on the relevant day, there is no evidence that there was some quarrel, my lord.
Diabetic disease also competent defense. I think this medical person. This will be the process. Happening with this hospital. Question doctors are coming. So we want this one statement to the police. Now, the police is, shouting. Then he said that he went to the field. He was told that yes, sir. If he's a writing, he's saying the issue. He knows who is a something.
Lordship,
Just a moment.
my lord.
And then that is that was you don't see it. It was from somebody else. This is the police. This is the main one. This is the, I've seen the incident of cutting on the this one. Even this one. So this is this. I've heard from the current people who I won't say their name. There's those in front of them and say to them, the same people have to do it. They must live to the two of the giants went to she's seen it. He did with you also. This something. CW1. That is not a question to him. Human voice. What's my answer? Yes. You want to use you want to do page 25.
Statement says page 58 and 66. August 58 and 66. 164. 58.
Just a moment.
Lordship.
Yes, Ms. Bina, please proceed.
Lordship, if your lordship considers the evidence of PCW2, because a doubt has arose in the mind of this honorable court regarding whether the presence of these two witnesses, 3 and 4. Now, if I take your lordship to the evidence of CW2, she was very much present in the house along with the accused person, my lord. And her residence is C, your lordship, page 68. Page 68 is the house of the accused Nita, situated in Hillock C.
Yes,
And in her deposition before the court, she has deposed, she was in the residence in her matrimonial home, my lord. May I take your lordship to the evidence of CW2, page 25. Second line, on the date of incident, I was at matrimonial home at Abhayapur, Rangapathar Gao under Sonari PS. On that day at the field of seeing a gathering and learned that my husband killed my brother. After some time, police arrived there. I saw cut injury marks on the neck of the deceased. Then crossed by prosecution. I have seen the incident of cutting my brother by the accused in my own. So there is a possibility that she has seen the accused person who happens to be her husband, cutting her own brother who came in the field, your lordship.
But Mr. Prasad is right. We have to exclude this part of the cross-by cross-examination by prosecution. I have seen the incident of cutting my brother by the accused. This we have to discard because in 313 statement that was not a that was not put to the
Material has to
incriminating
be-
evidence
has to
against
be
the
put to
accused
the
was not
accused
produced.
person. Lordship, may I see it once?
Please,
Please.
please. It is in the next page, page 26 onwards.
Lordship. Please, 30. Uh-uh.
All others are before that. If you come to page 30,
Yes.
question number 42 is the first question to the CW1.
Hmm.
And this CW2, next page is no question is put. So therefore, evidence of CW2 incriminating against the
Lordship, question number 4, page 33.
30,
3. CW1 Shanti Bhumis, your wife, in her evidence, deposed that this is Bokul Bhumis, was her younger brother. On the day of incident at a field, on seeing a gathering and learned that her husband killed her brother, what is your say? It is false. Being sister of the deceased, she deposed falsely.
no.
Regarding killing,
No,
assaulting part.
she's the hearsay witness as per question number 4.
Yes.
It says that on the date of incident at the field on seeing the gathering and learned that husband killed her brother. What do you say?
My lord.
So this is hearsay
Regarding,
evidence.
yes. After seeing the gathering, she has whatever maybe my yes. But regarding the assault part, lordship, there are some discrepancies here and there.
It's okay. You make a presentation because I'm just asking people the
My
question
lord.
so that it's
Lordship.
easier for us because we have heard Mr. Prasad.
Be-
So that is why.
Lordship, a doubt also arises whether it can be the PW 2 and 3 can be the perpetrator, your lordship, maybe, my lord. And there one more possibility is there, since the deceased went to the field to feed the cow and lordship take back the cows in the field of where the residence of accused person is there. So there might be assault might have been taken place. So your lordship will judge that, your lordship. There might be
No,
possibility.
the question is otherwise. The question is otherwise.
My lord.
You see, there is a incident which has taken place.
Yes.
Now so far as the inquest is concerned, it is by the police officer. We
Yes.
don't know whether he was empowered or
Yes.
not. Number one. Number two is that insofar as the nature of the injury is concerned, is by and large the inquest and the postmortem report are consistent.
Lordship.
That he has been assaulted in the head. It was almost cut off, except for a few strands which has held the head in the
Lordship.
shoulder. But the other part is that if the dao, which is a weapon of assault, is not said to be the same dao, because what has happened is you will find it at the inquest report. Which page?
Inquest is at page 62.
62.
My lord.
So please come to that inquest.
Lordship, the accused willingly surrendered before police with a Nagadao in his house.
In his house. Nagadao in his house.
Yes.
So therefore, this Dao must have some what you call you see, he was caught in the field.
Yes. Yes.
The evidence is he is caught in the field.
Yes.
The Dao is in the house,
Yes.
and
There's
therefore
no leading to discovery or something like that.
I'm not saying that.
Yes.
What I'm trying to say is that the Dao, if it's a weapon of assault, at least some marks in the Dao or something to say that this is the weapon of assault. It must be linked.
Lordship, but may I?
Yeah, definitely.
Lordship, because the lapses in the prosecution case, there are judgments, my lord, whether it will falsify the prosecution case. Lapses in the part of the IO regarding investigation, my lord. So whether it will falsify the prosecution
No,
case.
you see, there's one more aspect. Please consider that also
Right.
when you are making a submission. Number one, it is nobody's case that the accused from that field could escape and go back to the home.
Yes,
It's nobody's case. Now, the dao, which is a weapon of assault, and the assault takes place in the field, how will that dao go home?
there's no evidence to that effect.
There's no evidence to that effect, that he went there, concealed the dao, and therefore leading to discovery. So these are also the things which you'll have to
One
address.
doubt arises, look, in my mind, I do not know whether it arises in the mind of this honorable court. Regarding the evidence of CW2, my lord, since these two persons have grabbed the house, my lord. This PW2 and 3.
PW2 and 3, CW is driven out.
No,
Of
yes,
the
she
house,
was
huh?
driven out. She is the wife. So, my lord, the possibility, my lord. which
So we are not
might
saying
go-
anything.
Yes,
We are
my
not
lord.
saying anything because of a reason. You see, a house is empty, somebody has taken over the house.
My lord.
We are not making a
No,
comment.
not, somebody else. These two PW2 and 3.
No, it's okay.
Yes,
But we are not drawing any inference
my lord.
that because of this, they have
Whether
happened.
your lordship throw away the prosecution
huh.
case.
Maybe if I commit a murder in the house of X, maybe the entire locality will want me to drive me out.
My lord.
They don't want to decide with me.
My lord.
So therefore, they are driving me out from the locality. That's quite possible. But the question is that there must be legal evidence to connect the weapon of assault with the assault and
My
then
lord.
with him.
That is not there.
Because only two people have said that they have seen.
So, and these two people grabbed the house of the
No, that is okay.
accused. Yes.
That is okay. We are
Yes.
not on that.
Yes, my
The
lord.
subsequent action, we
Yes.
are not saying.
So linking that part is not there. Linking that whether the commission of offense has taken place from that weapon, which was used by the accused.
Because a lot of people, they say, have come. There was a gathering. These independent witnesses, what do they say?
My lord.
Come to the independent
Independent
witnesses.
witness, my lord, there is no independent witness to that effect, so that to substantiate the conviction. PW6 Kalidas Bhumi is a brother-in-law. He informs, my lord, he deposes. Shanti Bhumi, his wife of the accused, came and informed that the accused is killed.
But-
And there are two GD entries to that effect, one at 4:30 and one subsequently at 8:30, your lordship. Regarding that the information is given to the police station that the accused has committed the offense. One by Kalidas, one by the PW2, B2 Bhumis.
4 and 5.
Haridas is 6.
6 Kalidas, my lord. So, lordship, minor discrepancies regarding whether the place where the these witnesses whether they were on the back side or front side, because they say the wife of PW2, she was drying the clothes, and thereafter she came on the lordship gateway and she saw the accused person, and they also fled from the scene.
And what do you say about the fact of motive? Motive must be, some sort of motive must be brought in for the purpose of murder.
Not always, your lordship, when there are account of eyewitnesses, they see the occurrence.
This I went to the place of offense, and it didn't come to me. The next party did not be was back. The other sensitive have been bad like that. So, Shankar Hajong is not examined. Shankar Hajong? No. Not examined.
He's not a witness.
Hmm?
Not a witness. There is 164 statement. And in her evidence, she does not say anything about Shankar Bhatna. In her evidence, she says, I fainted. She doesn't say that I kept myself concealed in somebody's place.
Pardon me, I didn't get it.
That is the story. Shankar Hajong story is with regard to 164 statement. She kept her concealed herself. In her evidence, she doesn't say that she went to some other place and kept herself concealed to save herself from the accused. She says, I fainted.
But then there's another defect,
My lord,
and you'll tell us whether it is a defect or not.
I know.
Uh, You see. uh, Please come to page 51.
Lordship.
Exhibit 10 is the GD entry book.
Yes,
GD entry number 287 or 29, 2015.
yes.
So
It is
Now-
at 76.
in that FIR form, you said page 1,
Yes, my lord.
date of occurrence is 2015 at 3:30 PM.
Yes.
Information receipt date is 21/9.
The GD entry is at page 76.
No, that's what I
No,
understand.
no, yes.
But why-
Information received much later. Your lordship meant to say,
But how, yes, but why GD entry was made, and GD entry must be the information date receipt.
yes. My
FIR may
lord,
be later.
But the date is wrongly given, but 23, 2015 is wrong.
yes,
It should have been 20
9.
September.
Hmm?
It should be 20 September,
Page,
page 1. Date of occurrence of that, it should be September, madam, not March.
not March, this is a mistake.
Typing.
No, no,
Because the
no,
date
no, I am not
above
in
is
the, I am
21,
not on entry three B.
my lord,
I am on entry three C.
3C,
Three C, information received is 21-9.
my lord. The GD&T was at Safari Outpost. That is a different place.
Oh,
Under-
acha, acha.
under that
Okay,
police
okay, so
station.
there is a,
The FIR was given there at around 8 PM or 6 PM in the evening.
okay, okay,
Next
so
And
there
then
is
it was
a
sent to the
explanation.
police station.
There is an explanation.
Yes.
Okay, okay,
At
okay.
page 77.
okay.
Lordship, taking into account the 313 statement, I may be wrong in submitting, your lordship. Taking into account the statement given by the accused person at 313 regarding lordship, the conduct, my lord, the motive of the, although not of the accused person, but of the accused person, my lord. Lordship, may I, motive of the witnesses, your lordship, regarding grabbing of land, coupled with the evidence of CW2, my lord, who is the wife of the accused person. Lordship, a doubt arises, my lord, they are the, this accused, when the witnesses, my lord, PW2 and 3, as well as the lordship, the evidence of PW6, my lord. Although PW6 has not said, he has seen the occurrence, but Shanti has reported him, he said. Lordship, probably, lordship, these two persons, PW2 and 3, although it goes against the prosecution, my lord. Because your lordship, he says, he has some quarrel with B2 Bhumis, Mongol Bhumis and Kalidas Bhumis on landed property acquired by deceased Bokul Bhumis. B2 and on this matter, Mongol, B2 and Kalis attempted to kill Bokul in the month of Aghon. I have mediated the matter.
But evidence was not led to that dispute, if any. If the,
Yes. But your lordship,
if the,
CW2 has said,
if the accused, what you call, initiates a defense, he'll have to prove even
proof
that proving is not there.
But CW2 has said they have acquired, they have dispossessed her and
No, you
occupied.
see, a quarrel prior to the date of incident is something else.
My lord,
Grabbing of land after the death is something else.
yes, my lord.
So subsequent event can't be a
Taken into
consideration for the
account.
court to say
Yes.
that, to doubt the incident which has taken
So,
prior in point of
yes,
time.
my lord, if your lordship discards that part, then the evidences of 2 and 3 will remain. So your lordship will may ignore the discrepancies which is minor in nature, my lord. Regarding seeing the occurrence, the place where the these witnesses were standing, whether actually they have seen the occurrence or not. So evidence of PW 2 and 3 will stand, your lordship. There's nothing to disbelieve apart from some discrepancies in the prosecution case. Here and there, my lord.
Okay, we'll think it over.
Lordship. I leave it to your lordship's discretion.
Fix it again on Monday. Then we'll think over.
So lordship.
We're fixing it on
reserving
Monday.
My lord,
We're fixing it on Monday. Let us first have a meeting of mind, then we'll
lordship,
say whether we are reserving it or not.
my lord. Obliged. Regarding the lordship defect in the prosecution case, I'll cite 2 decisions. I'll give the citations.
For Mr. B. Prasad, learned amicus curiae, whose submissions are concluded, reserving right to reply. The submissions of Ms. B. Buyar, learned senior counsel, and APP for the state, assisted by Ms. M.
B. Bora.
B. Bora, learned counsel, remains inconclusive. List on Monday, 7/8/2023.
Lordship will not hear us on the day. Lordship. Yes.
Inconclusive.
Inconclusive. Right. Lordship. And on the day I'll decide
Yeah.
the decisions. Lordship, I'll just take 5 minutes leave, my lord. Let her continue with her matter. I'll come back, my lord. May I please? Lordship, the matter is against the affidavit against the judgment and order dated 18/6/2000.
Yeah, just. Yes.
The next affair is that on dated 10/12/2002 afternoon, para 2, Your Honor, para 2, page number 4,
Page number 4.
4 of the page. Para 2,
Yes.
second para, point number 2, para second para. The affair reveals that the one Bantu Sharma, son of Sri Horen Sharma, aged about 13 years of village Sandpusi under Nalbari PA police station, was found missing from the afternoon of 10/12/2002, and while the informant and other searched for him, came to know that the deceased boy was taken by accused Manav Sharma. That should be pointed out. He was abducted by the Manav Sharma one, not
Yes.
by the present. So, in his bicycle in the evening, while nabbed and interrogated by the police, the said Manav Sharma confessed to have kept the victim boy with some Gokul Das, Kalisharan Das, and Jitu Das, not by the present accused or petitioner. Lordship. So subsequently, on interrogation by the Nalbari PS, the said Manav Sharma confessed that he abducted the minor victim by kept in custody of his co-accused, this present petitioner Pranab Talukdar and Bhupen Talukdar. So, Your Lordship, the case was registered in Para 3. The Nalbari PS case was registered under section 240 and 147, 364, 302, and accordingly punishment was awarded under section 364, then 302 and 201. No. Yeah, please. Honorable Court may peruse the page number 33 of the petition. There are
33.
35, pardon. There are 33 of the judgment. There are 33 of the judgment. Now, from the evidence discussed above, it is seen that there is no direct evidence against the accused persons. In fact, none of the witnesses examined by the prosecution saw the accused person to commit murder of Ranku Sharma. This is the main point, Your Honor. The prosecution decided that case upon the circumstantial evidences. So, according to the court decision, the last line of this para, the first of the circumstances was the last same theory. So, upon the last same theory, it was decided as the accused were the murderer of the victim boy. But last same theory was as seen from the PWs or examined of the witnesses. All the witnesses seen the Manav Sharma with the victim, not the present petitioners. Your Honor. May peruse the page 36, Your Honor.
Yes.
Subsequent line number 10 number line from the above. The second circumstance proved by the prosecution is the recovery of the demand letter from the possession of the accused Manav Sharma, which clearly indicate that the kidnapped Rantu Sharma with intention to demand a reason from his father. The defense did not question the recovery of the demand letter from the possession of the accused Manav Sharma. Now, let's see. You may peruse the page number 10.
10.
That is Roman 4 number point. The ground is that the authorship of demand letter recovered from the possession of the accused was not known. There is no handwritten expert report is there. No forensic report is there. Page number 10. Of my petition.
Of the memo appeal.
Roman 4.
Of the memo appeal.
Yeah.
Yes.
So for that, the authorship of demand letter recovered from the possession of accused was not proved. The letter had also not borne the name of the addressee. Moreover, nowhere in prosecution investigation it was proved that the accused claimed money from the deceased family and attempted to gain money. The learned session thus failed to appreciate the fact that none of the accused has any telephonic conversation or any other attempt of extortion of money. So, according to this, the second circumstantial evidence is actually not proved, Your Honor. Then again, to page number 36, Your Honor. In the bottom, from bottom the 7th line. The third circumstance is the extrajudicial confession made by the Manav Sharma in presence of the village people before arrival of the IO, when he confessed before the village people that he kidnapped the Rantu Sharma, kept him in the custody of some boys of Sonpur. The fourth circumstances prove that the prosecution is that accused Manav Sharma led the police party first to Sonpur, then to the house of the Pranav and the present accused. So, Your Honor, according to the PW witnesses or prosecution witnesses, all seen the Manav Sharma with the victim as a last century, but none had seen the present petitioner to murder the victim boy. So, as per the circumstantial evidence, the case was actually not proved as well. Page number 16, para 5. Page number 16, para 5, the lower portion. But Bhupen Talukdar on his examination under section 313 CRPC stated that he confessed his guilt before the magistrate out of fear of the police. Accused Pranav Talukdar on the other hand stated that he confessed his guilt before the magistrate as taught by the police. Now, you may go for the statement of 364 of the accused, Your Honor. 364 statement.
Where?
Actually, I am not putting the maybe record is there.
Achha.
LCR you may find here. Record was not provided to me directly.
Well, here is there.
Yes, I am looking at the
Huh.
LCR. Actually, I may submit, Your Honor.
Yes, please continue.
364 statements reveals that both the Pranab Talukdar and the Bhupen Talukdar accused were they almost minor. They were 18 years and 20 years at the time of occurrence of the offense. So, in that regard, the confession statement was maybe out of the fear or out of the threat. That may be considered, Your Honor.
What were their ages?
The Bhupen Talukdar was of 18 years and Pranab Talukdar was of 21 years.
21 years.
21. So they were at the tender age. So out of fear, they may be confessed, which cannot be taken as a confidence, Your Honor. That is the murder. And specifically, none were seen whether Manav Sharma committed the offense or the present accused committed the offense. None of the witness seen the fact. Moreover, Your Honor,
No, you see, for the, we are examining this for the purpose of bail
Yes.
today, right? There are,
not only bail, Your Honor, the
no, on merit, we are not taking it up because we were hearing the last item
Okay.
where we could not conclude the
Bail
argument.
Your Honor.
Because in a criminal appeal,
Yes.
we'll have to go through the evidence and then take a decision. We can't jump into conclusions. But for the purpose of bail, we can definitely, we can choose a particular evidence and then say whether the bail would be, the appellant would be entitled to bail or not. You see, apart from other witnesses, the witnesses who have been examined at the later part from PW 10 onwards, they are all consistent in saying that the main accused, that Manav
Manav
Sharma,
Sharma, yes.
he took the police party to the house of two persons, and when the victim was not found, then they led to the house of this
The other, his brother.
Pranab and
Yes,
Bhupen
yes, yes.
Talukdar. Now, this Pranab and Bhupen Talukdar, they led the police and the villagers
To the
to the grave where this boy was murdered. And they also produced this spade, which had a hole in it, through which the dead body was cremated. And,
just cannot prove
and the fact that the boy was strangled by a rope, that rope was discovered, the ADC was there.
behind the bush.
The nylon rope with a knot in the end that was found, and this rope was also exhibited as a material exhibit, and the spade was also exhibited, and so therefore you see, leading to discovery under section 27 of the Evidence Act, I find that there is a complete chain insofar as the evidence leading to discovery is concerned, and the evidence says somewhere it has come that these boys were also offered 30,000 rupees to murder this
But
kidnapped
that was
boy.
not proven.
Judicial confession is there. Judicial confession is there,
Judicial commission,
my lord.
that I missed out.
recorded by the magistrate. For one accused, they can prefer an application under to give the benefit under Juvenile Justice Act, my lord. They can plea of juvenility because on the date of occurrence, he was below 18 years. Pranab Talukdar.
I think it's Bhupen Talukdar.
Pranab Talukdar said 21 years.
Yes.
Or
So
then
it will be Bhupen.
Pranab Talukdar was
It will be
18.
Bhupen.
Pranab Talukdar was 18.
I have some file for a juvenility plea. Oh.
Huh? But then after the trial, looking back to the juvenility. What is the principle? She is right in saying if you take the plea of juvenility for this second accused, and if you can successfully show that he was a juvenile, then perhaps we will have no option but to set aside the conviction and send it back to the
Yes.
for a retrial before the Juvenile Justice Board.
Ordinary court cannot take.
But we don't find any circumstances where there is any defect in the chain of circumstances so far as the this.
Other person has given judicial confession. I have marked it, my lord.
Okay,
Proper procedure has been followed, my lord, while recording his confession.
okay. Where's that, Ms. Bhuyan?
Lordship. So I have marked it.
Because this order does not contain that list of exhibits, so I couldn't find out.
Completion to record in the exhibit course, and completion to That's what we do. That's what
Both of them have confessed,
No, one has not, only
Both.
one.
both.
Both of them.
One is accused Pranab Talukdar,
My lord.
and immediately thereafter is Exhibit 8, Bhupen Talukdar.
Okay.
Bhupen Talukdar also says আৰু দুইজনে এই ল'ৰাজনৰ গলত ৰছীৰে হেৰিয়াই বান্ধি আৰু মুখত কোপা দি হত্যা কৰোঁ। Both of them are consistent statement, same statement.
So lordship, at this stage, may I submit, my lord, regarding the bail prayer made by my learned friend as regards the accused appellant Pranab Talukdar, your lordship will not consider that. And regarding other accused person, since he is a juvenile, at the face of it, my lord, because in 313 his age is recorded as 18 years, your lordship, they may prefer appropriate application as per law.
You see, while recording this statement of the of this two accused, this statement was recorded by judicial magistrate second
Yes, my
class.
lord.
As per para 7 of the confessional statement, Pranab Talukdar is 18 years
Yes. 18 years.
and the other accused is aged 22 years.
21 years, I was.
This confessional statement was recorded on 2002.
Yes, my lord. Date of occurrence is 11/12/2002. And
So 18 years, we don't know whether it is still juvenility or is past the juvenility, we don't know.
plus there are judgments, my lord, benefit may be given +2 -2, it may be. Right? So lordship, if they prefer an application before this honorable court, lordship may send it for lordship before the learned
No,
district
what
judge,
I'm trying to ask you,
session judge, my lord,
let us for the timing assume
my lord.
that on the date of occurrence, the accused was 18 years. Let us
Yes.
say he is 18 years.
Yes,
Now, the certificate of birth,
yes,
if it discloses that he was 18,
yes.
can there be a presumption of reduction of age?
Lordship, as judgments are there, your lordship, because under the juvenile justice rules, my lord, birth certificate, in absence of birth certificate, municipal certificate issued by municipal authorities, and in absence of that is high school leaving certificate, and last is the ossification test, my lord. My lord,
So,
medical,
understand, if there's
yes,
a documentary evidence
yes,
showing that the accused
yes,
is 18 years,
yes,
then presumption of juvenility can't be taken. It is only when there is an ossification test done in the absence of documentary evidence,
yes.
then only +2 years will come.
Yes, lordship, yes, but they have to substantiate first that he is a juvenile, because when the 313 statement was recorded, his age was 18 years.
18 years.
Lordship, and date of occurrence is 11/12/2002. So lordship, he would be 17 years. Lordship, but they have to, if they take the plea, they have to substantiate that by way of lordship documentary evidence.
Prayer for bail we are rejecting. And we'll
Yes,
fix this matter for hearing after preparation of paper book.
yes.
Advis R. Goswami, learned legal aid counsel,
Yes.
appearing for the appellants, as well as Ms. B. Bhuya, learned senior counsel, and APP for the state, assisted by Ms.
P. Bora.
B. Bora, learned counsel. Next. This interlocutory application has been filed under section 389(1) of the CRPC for whereby the applicants have prayed for suspension of the sentence dated 18/6/2003, passed by the Learned Session Judge Malbari in Sessions Case number 2 of 2003, thereby convicting the applicants under section so page 1, 147, 364, 302, 201, 387 IPC, sentencing the applicants to undergo imprisonment for 10 years for offense under section 364/34 IPC with stipulation for fine along with stipulation for default sentence and to undergo life imprisonment for offense under section 302/34 IPC with stipulations for fine and default sentence. As well as to suffer rigorous imprisonment for 1 year. No, sorry, 5 years for the offense under section 201/34 IPC with stipulation for fine and default sentence. Next paragraph. Having regard to the evidence of the PWs, specifically regarding the applicants leading the police to the recovery of the dead body, as well as considering the confessional statement made by both the applicants before the judicial magistrate, admitting their guilt, court is not inclined to release the, not inclined to suspend the sentence imposed on the applicants. Next paragraph. Nonetheless, on consideration that the applicants have been taken into custody in the year 2002, the court is inclined to direct the is refused. Prayer for suspension is refused. Application stands disposed of. In the main case, you have heard so and so. Taking into consideration that the appellants are in custody since the year 2002. Court is inclined to direct the registry to expeditiously prepare the paper book, preferably within a period of 4 weeks. Next paragraph. List after 4 weeks.
Lordship, may I? Because after going to the records, as we have come to know, Lordship, as we have discovered, your Lordship, that the accused appellant one is seems to be juvenile on the date of occurrence. Lordship, it's up to them, but Lordship, appropriate application, if so, advice may be filed by them, your Lordship. Can it be observed?
No, you see, observation of the court means that we take we take cognizance of the fact that there was a juvenility. Because today we have no material to presume that he was juvenile at that point of time. Therefore, drawing up a presumption by a division bench of the court would have far-reaching implications.
Because at the face of it, while recording Trivanti statement, he was 18
No,
years.
18 years.
I know.
So 18 years, we can't presume that it was less than 18 years. That
No, on the
presumption,
date of recording Trivanti, he was 18 years and occurrence
No,
prior
you
to
see,
that, my lord.
you see, we
Lordship, it's up to them if they want to,
No, I'm
Lordship, it
just
may not be
let me
observed, then,
tell
my
you.
lord.
You see, if you ask me my age today, what would I say my age is?
About
So about so and so years, if I
Yes.
don't want to disclose my age,
my lord.
correct? So I'll say about so and so years. Now, the fact is that if I, because if I say that I have crossed the age, so let us assume that I'll be 61. So if I say 62, then I am superannuating
Yes.
today. If I say 61, that is appropriate, but the 61 doesn't mean that on a particular day I was 60.
Yes.
So because when as a division bench we are writing something, we'll have to take responsibility of making a statement that
Lordship.
on that day he was not a major, he was a juvenile.
Yes.
For that, we don't have particulars.
Lordship may not observe. No, if they wishes, they may prefer.
If they raise it,
Yes, my.
then okay, from the document we can say that there appears to be a
Yes, my.
case when he was
Yes,
juvenile.
Yes.
So that is
Then
the
your
issue.
lordship may take out instance.
Correct. But you
Yes.
take cognizance of what she has said, you please understand and do it accordingly. She's right. I'm glad she has pointed out this fact.
My lord.
Any other division bench matters, we are not taking it up. We'll sit single bench for some time.
Probably Lisa got exhausted, my lord, for today.
So, finish with it. Five and ninth. So what is this IA for? Yes.
But my lord, the photograph that was moved to 11 was not given the department, which shows my lord that there is a marking, my lord. But in that mark, my lord, it is down to around just the step of the house. So now, my lord, we have seen, my lord, like new photograph, which shows that for the purpose of the drain, they are digging, my lord, 1 foot this side and 1 foot that side. Then in the middle, they are. My lord, constructing
Okay,
the
then
drain.
ninth, we will have to hear PWD also.
Yes.
Okay. Item 5. On the prayer made by both sides are represented. On the prayer made by Mr. G. Chaudhary, counsel for the applicant. List on 9/8/2023.
May I please, Your Honor? Your Honor, I'd like to mention for listing an IA. For a correction, in WBC method, there are some minor typing mistake. Your Honor.
The bill में कहिए.
Item number 2, bail hearing.
Your lordship, my lord, your lordship plus order. Only. By this time, 7 witnesses already examined. And out of that. Your lordship kindly see the first one.
No, there is okay, but only that question, 2 questions.
Only
that are
that question. I simply find I place only one judgment, that was the latest one, my lord. The next one. Paragraph 18, 19 and 20, my lord. It says, my lord, it is not, evolution is not there, my lord. But prima facie to look at the, whether ultimately it will be proved or not, that much. That was decided on, my lord, March 20, 2023. 28 March.
Paragraph.
Paragraph 19, 20, your lordships. One latest pilot of coordinate range of this honorable court also. I think.
In your case, there are how many witnesses?
Total my dot, total witness 9.
9.
9. Now 7 already examined. And the 7 your loss will have paid from page 31 onwards. 31 PW1 is the informant. Rest witness madam. Whole question madam, page 31, your loss will find last 3 lines. Page 31.
Yes.
Thereafter, just my line. Thereafter, I called 4 local persons, namely Jahanari, the PW2, Abbas Ali, PW3, Amanuddin, PW4, Abdul Khalik, PW5 to become witness. And these I have annexed, my dear, you will find from next page 35 onwards. Only page PW2 says, my dear, he has sent some packets shown to him by the in charge. That page 35. And rest only after coming from namaz, my lord, his signature was taken. The page 36 also almost same line. Completely, my lord. I met police personally, but after namaz, asked me to put signature, I put signature. So if Caesar goes, my lord, nothing remains, sir. Then page PW my lord 2, 3, 4 also page 37. He requested me to put my signature, I put signature. Page 37, PW4. PW5, page 38, same thing. Police requested to put my signature on a piece of paper. Accordingly, I put my signature. I do not know the contents of the paper. My signature was taken. Then page 39, minus 6. He does not have anything. And PW7, my lord, I'm giving your lordship that I am having. PW7. Subsequently, my lord. This is 7, my lord. It does not have anything.
That I have been a coordinate bench, my lord, the latest property. Today, 342 days. Arrested on 27, forwarded 28, 822.
Arrested when?
Arrested by the 27 arrested, forwarded 28.
28.
28, 822. Page 15 is the forwarded.
So how many days today?
Today's my calculation, madam, I'm very poor in arithmetic. 342 days, madam. Your lordship is very expert man in this life.
No, I cannot claim to know more than you, so I'll have to reject your
But
prayer.
whatever you find, your lordship make own calculation. That is all.
Okay, I'll consider and pass on this.
Obliged to us.
You have to say anything?
That is there. No, also fact.
If your Caesar witnesses, all four Caesar witnesses, they go, they don't.
The house of the accused person where my thumb is in a stated some like it. The house we have in the.
But that is not how the Caesar is made.
That is lordship, that is there, but everything is seized from his position. That is also there. From his house lordship. Huge quantity. 11600 nodes of tablets and all get positive test.
Because in NDPS, that is not the procedure. Each and every Caesar must be done in the presence of the witnesses. And your PP there did not declare him as hostile.
That was not done. Anyway,
Okay, I'll consider and pass on this.
obliged to us.
3. May it please your lordship. May it please your lordship.
Yes.
Total six witnesses. Out of 6 witnesses, lordship, all witnesses are examined. And 3 witnesses are independent witness. As per its independent witness, lordship, they stated that the police put their signature on the blank page on Caesar list, Lordship. Kindly see the page 35.
You were arrested when?
I'm arrested 2 days on 336 days. 3922. Kindly see the page 35. The statement of PW 4. Page 35. While I was going from the Moscow to my house, some police personnel met me near the Tinali, and I was requested by them to put my signature on the pieces of paper, then told me that they were going for ride in the Digaltari village and accordingly I put my signature in the said paper which was in blank paper. And PW 4, statement of PW 4 also. And same statement has been made by the PW 3 also. Thirty-four page PW 3 also.
Which page?
35 PW 4 Lordship. Statement of PW 4. While I was going from Moscow to my house, some police personnel met me near the Tinali, and I was requested by them to put my signature on the pieces of paper, then told me that they were going for ride in the Digaltari village, and accordingly I put my signature in the said paper which was blank paper. Page number 35. PW 4. And same statement has been made by the PW 3. PW PW 1 also. Same statement. But his cross examination there, Lordship, kindly see 32 personally. Same statement, Lordship. Co-equus already announced on bail Lordship at page 46. Please put their signature on the blank pages.
Yes,
Lordship, co-accused person already enlarged on bail.
which page?
Page 46, Lordship,
40?
46.
That was on a different footing, but the articles were recovered from your house.
Lordship,
So this will not come in your aid.
Lordship. But, Lordship. The witnesses. Statement. Lordship, 2 days on 33.
Yes, you have anything to say?
As PW1 have stated, Lordship, I saw the police personnel along with CRPF in front of the house of Nizami. I, along with Khalid, went near the police party and they asked us to accompany the police. So he was there, Lordship, by
PW1,
PW1.
which page?
Page number, Lordship, 31. Taken, my wife, Santu Bibi also came, myself and Khaled were taken inside the house of the Nizami Rahman. Police recovered the tablets from the house.
But Lordship, kindly see page number 32, cross examination,
32.
32.
Yes.
Last para, Lordship. Initially, police did not take my signature. After apprehending the request, my signature and taken and the seizure list was prepared in the house of the request person. I did not. Lordship is saying. My signature was taken on the veranda of the house. The police take their signature on blank this, Lordship.
Okay, let me go through the accounts.
If I am a local person,
You Mr. Enuddin.
anything, Lordship.
Okay. And consider passwords. Let me go through the case records.
Obliged.
Four. Fashion phone, Lordship. I have gone through the scan copy. Nothing up to date is there, Lordship. Everything was very previous of 20 and 19. 2021 and
So you'll have to call for the
LCA. So what is the status, Lordship, at present?
this is evidence up to which PWs are here.
No evidence. were taken, Lordship.
No evidence.
No
is there.
evidence, Lordship. I have been arrested on 21/5/19. And I am living in jail for 804 days, Lordship. Trial
Okay,
has
then
not
I'll
been
call for the
commenced yet.
updated case records. Mr. A.S. Ali,
AK Sharma.
A.K. Sharma,
Yes.
counsel for the petitioner. Ms. A. Begum, learned APP, has perused the scan copy of the records of PRC 1118 of 2021, which is available in the records of BA 3409 of 2022 within bracket disposed of. And it is submitted that updated case status would be required. As the records are up to the year 2022. Next para. Accordingly, next para. The Learned Counsel for the petitioner submits that the petitioner was arrested on 21/5/2021,
No, Lordship. 2019.
2019,
Yes. Oh, 21, sorry.
21.
21, extremely sorry. Lordship.
21. And there's been no progress in the trial. Next para, accordingly, the court is inclined to direct the registry to obtain the updated status of trial of PRC case number 1118 of 2021, arising out of Hojai PS case number 888 of 2019, pending for disposal before the court of learned judicial magistrate first class. Hujai Shankardev Nagar. Including scanned copy of the order sheet. From December 2022 till date. Record of evidence, if any recorded of any witnesses. Next para, the registry shall send the requisition through email with liberty to the said learned court to send the records by scanned copy of records by email for being placed before the court. Today is 4th. This one, 14/8/2023. 14/8.
48.
Huh.
Obliged.
So they will take some time to communicate.
Definitely. Lordship. Deeply applaud.
Item number 1.
On Tuesday. Because now I'm in a, my
Yes.
roster has been changed.
Division is here.
Because for even for this bench, the Honorable Chief Justice has given a special permission to constitute this bench for some time. Because even on the next date, I know the amount of matters which are coming in. Next date also you'll have to. Huh. Because his matter is only simple
Affidavit.
affidavit.
I will not take much time.
No, but on the next date also, we don't know. The matters will be taken up in the. Huh? You have to do it because
Yes, I
Uh,
understand.
the division bench takes a priority. I can't break up
Yes.
the division bench, and because the second part is that my brother may not be available after that. So therefore,
Yes, yes.
whatever matter, we can't
Cannot be
keep it
part-
parted.
Cannot be kept.
We cannot keep it parted. It's the Mr. T.J. Mahanta, Senior Counsel, assisted by Mr. J. Sharma, Counsel for the petitioner, as well as Mr. S. Bhattakur, Learned Standing Counsel, Learned Counsel for Respondent number 5, and Mr. R. Gogoi, Learned Standing Counsel for Forest Department. Next, due to positive time, matter could not be taken up. Next, this being a parted matter, the registration raised the matter on 8/8/2023. Okay, but we have a gentleman's understanding on that day, we'll do it.
Yes, that,
No, tomorrow it will not be listed because by the time I send my files.
usually, my lord, Friday we won't work, but today we have to work, my lord. That's why we have to go to the.
But when I was there, I took holidays on Sunday.
And there, yes.
Friday I did work because since
Saturday, yes.
I had the background of trial court.
Yes.
So first and third would be open.
Yes.
So therefore, I would sit on a Friday and take a holiday on Sunday.
Sundays are most tedious this one.
No, Sundays I never worked. Sundays I never worked. Maybe once in a blue moon, I don't know, but
Yeah.
Sundays I do not work. So otherwise, I would not have given any time to my family.
Yes, yes. That is.
One day was very well. I had to take a leave. Otherwise, my family would not be a happy family.
Okay, fine.
And you know, last 2 weeks, apart from all the judicial works, I had
Administrative.
on administrative side, I had seen 180 judgment, 280 judgments. On administrative side, I had to see 280 judgments. Now, second bench has come. I am now evaluating 140 judgments, which I have to complete within by end of tomorrow and submit. This is only a part of
Yes.
the job which I am doing.
Oh, okay. আপুনি লাষ্টত 15 তাৰিখে বিচাৰিলে নেকি ন? মই চাই দিছো 9 তাৰিখে গৈছে দিয়ক হা, এটা 9 তাৰিখে আহিব হা, 9 তাৰিখে আহিব, হ'ব ঠিক আছে, চিন্তা কৰিব 9 তাৰিখে আহিব হা। আজিকালি সাপ্লিমেন্টারি খনত সাৰৰ সিঙ্গল বেঞ্চ এটাও ডিসপোজ নহল, এইখন আমি এতিয়া পঠাম নে তালৈ জুডিচিয়েল লগে? এতিয়া ডিভিজনখনত যে আই এটাহে ডিসপোজ হ'ল, এতিয়া আইটেম আছিলে 28, the order was 28 দিব পাৰি
এটা যে লেপটপ হয়
দুটা লিড ওভাৰ আছে ন, তাকে একটা অর্ডার পর 26 হ'ল ডিসপোজ তো নাহে আৰু
নহয়
পথালিটো দুইটা মিলে এটাহে হ'ব, আজি পথালিখন নহয় আৰু